The federal government has accused the chief judge of the Federal Capital Territory of illegally transferring the case against former member of the House of Representatives, Farouk Lawan. The federal government, in an appeal to the Abuja Division of the Court of Appeal, said the FCT chief judge transferred the part-heard bribery trial against Lawan from one to another in March 2017. Lawan is facing a criminal trial for allegedly collecting $620,000 from the chairman of Zenin Petroleum and Gas Limited, Femi Otedola, during his tenure as the chairman of the House Committee on Fuel Subsidy in 2012. Lawan's case has been transferred from Justice Angela Oduka, of the Lugby Division of the Court, to Justice Yusuf Halilu of the FCT High Court in Jabi, Abuja. After a ruling dismissed FG application for the return of the case to the former trial judge, a private lawyer prosecuting Lawan on behalf of the federal government, Adgboyegawamilo, San, filed a 3-ground notice of appeal and subsequently his appellant's brief against Justice Halilu's ruling. Owamlo said the transfer was not only wrong but illegal. The lawyer alleged that taking the case from Justice Otedola after 4 out of the 5 prosecution witnesses have testified contravenes the provision of Section 98(2) of the Administration of Criminal Justice Act. He also argued that Section 98(2) of the Act expressly provides that the power of the chief judge to transfer a case shall not be exercised where the prosecution had called even one witness, let alone 4 out of the 5 proposed witnesses. We submit that the learned trial judge erred in law in the interpretation of the law when he held that the Honorable Chief Judge has unfettered powers to reallocate any criminal case whatever the stage of prosecution, provided it appears to him to be fair and just. We submit that the Chief Judge, on the undisputed facts of this case, was wrong and acted without jurisdiction when he unilaterally transferred a part-heard and nearly concluded criminal case without and in total disregard for the ACJA. We submit that subsection 2 of the Administration of Criminal Justice Act mandatorily provides that the power of the chief judge shall not be exercised where the prosecution has called 1 witness, let alone 4 out of 5 witnesses. The consequence of the exercise of power of the chief judge in the face of mandatory prohibition is that the transfer of the appellant's case after 4 witnesses was illegal, null and void, Owamlo said.